All right, so we're back on slide 40. The class is reinvigorated. Played another cute video of my daughter. So the next part of the Marbury saga is as follows. So Jefferson, now president, says that he considers the commissions of the 42 midnight judges void, including Marbury. Remember that the commission that the justice or judge got was how his authority was recognized. It was how he was known to the people at the courthouse and the people on the streets. There was no facial ID, there was no fingerprint recognition, there was nothing like that. They just had this piece of paper. So, yeah, Marbury's was considered void as well. And that act was justified by the fact that the commissions hadn't been delivered to any of the judges by the end of Adams' last day in office. James Madison, who would succeed Thomas Jefferson, was appointed as president, was appointed by him to be Secretary of State. He was directed by President Jefferson not to hand over the commissions to any of the appointees. Now, do you think the 42 appointees are going to have a problem with that? Yeah, I probably would. Yeah, deprive me of a good gig. So there is a big power struggle that ensues after that. These non-commissioned judges, yet appointed and confirmed, appointed by the president, confirmed by the Senate. Marbury took his lawsuit directly to the Supreme Court pursuant to the Judiciary Act of 1789. This is what the Judiciary Act of 1789 says to do. And bringing that suit directly to the Supreme Court was Marbury's great mistake. Marbury sought a writ of mandamus as his remedy, which is a court order requiring a government official to carry out a non-discretionary duty. And that would have directed Madison to transmit Marbury's commission to him. Madison, Secretary of State Madison, would then have had to hand it over. There are three questions that the court asked to answer. One being, is Marbury entitled to his commission? The answer to that, yes. He was entitled to his commission. Did Marbury have a legal remedy under U.S. law? Answer to that, yes. So things are going Marbury's way, at least for the moment. Was it proper for Marbury to file his lawsuit in the Supreme Court in the first instance, or should it have been filed elsewhere? Now, what do you think the answer to that question is?
No.
Right. Why do you say no?
You said it wasn't going to go his way.
I said it looked like it was going his way so far.
Yeah, but
There's only 1 point left.
it's a big
Well, that's true. That's true.
term for the worse.
All right. Yeah. No, it was not supposed to have been filed under the Supreme Court at first. So this stuff up here, this is all about the commission. We talked about this, why that was important. So Marbury had earned a valid commission. And Chief Justice Marshall, the Federalist, said that this commission was effective for 5 years. He had a right to that commission, and the refusal to deliver his commission violated Marbury's rights, and there had to be a remedy for that violation. Point 2. The court scrutinized the 1789 law, the Judiciary Act, which I said was going to be important. This act said that the U.S. Supreme Court was indeed able to issue writs of mandamus in cases to any persons holding office under the authority of the United States. So contrary to that new law, the Constitution itself limited the original jurisdiction of the court. Original jurisdiction meaning cases that the court is entitled to hear in the first instance. The Supreme Court mainly acts as an appellate court, meaning cases get brought up to the Supreme Court through the system. And this original
I've been in the library.
No. That's all right. That's perfectly all right. Thad the Verbal Impaler. That's the best title, I think, for a paper on Thaddeus Stevens.
I was hoping I would point off that.
No, I like that.
Thank you.
I quite like that. Thad the Verbal Impaler. If you did your term paper on Thaddeus Stevens, is that not a good description of him? Yeah. So, we're talking about the Supreme Court. The paper you have in your hand is your attendance grade. Bring it back Thursday. If you know where you were on any of those days that I have you listed as missing, write down where you were. All right, we're still doing attendance. I'll still add the 4 meetings that we have to your overall score. All right, now that has been dispensed with, we're talking about the Judiciary Act of 1789. So contrary to the new law, the Constitution limits the original jurisdiction of the Supreme Court to hearing and ruling on cases for the first time, rather than as an appellate court to all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be a party. So in all other cases, the Supreme Court shall have appellate jurisdiction. So the Judiciary Act of 1789 and the Constitution are in conflict. Which supersedes the other? Which one do we listen to? Louder for the people in the back, Abby. The Constitution. Yes, we listen to the Constitution. And believe it or not, it was Chief Justice, big-time Federalist, John Marshall, who came to that conclusion. Marbury could have and should have filed his lawsuit in the federal trial court in the nation's capital. That's where it should have gone. The Judiciary Act, though, specifically gave original jurisdiction to the Supreme Court to grant orders to people holding office, which now it's debatable since we know about the commission and all that entailed back then, whether Marbury did hold office validly. Yeah, no, it's okay. So the Judiciary Act gives original jurisdiction to the Supreme Court to grant orders to people holding office under the authority of the United States. And again, it's fishy, it's arguable, debatable whether that applied to Marbury even because he didn't have the commission, compelling them to perform a non-discretionary ministerial duty like delivering a valid commission to an appointed and confirmed federal judge. Congress was butting heads with the Constitution by passing this law. Can Congress give the Supreme Court original jurisdiction to hear a case when the Constitution did not? If not, would the distribution of jurisdiction in the Constitution be form without substance, as Marbury famously asked? How would this conflict be resolved, and who should resolve it?